Can a former president, Donald Trump, be removed from all state ballots under the 14th Amendment? A provocative question indeed. It's a query that brings the 14th Amendment into the limelight, a constitutional provision often overshadowed by its more famous siblings. And yet, it may hold the key to understanding the ongoing controversy surrounding Donald Trump's potential disqualification from the 2024 presidential race. The stakes are high, the implications wide-reaching. This isn't just about one man's political future, but the very interpretation and enforcement of our Constitution. So let's delve into the events leading up to this situation. The series of events began with a lawsuit filed by a non-partisan watchdog group, Citizens for Responsibility and Ethics in Washington, better known as CREW. This lawsuit was not just another document in a court's archive, it was an attempt to prevent Donald Trump from appearing on the 2024 presidential ballot in Colorado. The foundation of their argument was intriguingly anchored in history. They argued that Trump's role in the January 6th insurrection disqualifies him from running for office, and the legal basis for this argument, none other than the 14th Amendment of the Constitution of the United States. Now, you might be wondering, how does the 14th Amendment come into play here? Well, this amendment, adopted way back in 1868, includes a clause that disqualifies individuals from holding office if they've engaged in insurrection or rebellion against the United States. CREW contended that Trump's actions surrounding the January 6th events constituted such a rebellion. Trump's lawyers, unsurprisingly, didn't take this lying down. They launched an array of legal challenges, attempting to get the lawsuit dismissed. One of their primary arguments was that the lawsuit violated free speech laws, yet the wheels of justice continued to turn, undeterred. Despite efforts to dismiss the lawsuit, Colorado District Judge Sarah Wallace ruled that the case should go to trial. This ruling was a significant moment, a green signal to the lawsuit that could potentially disqualify a former president from running for office again. But as we all know, in the world of law and politics, it's never over until it's really over. The trial concluded with a groundbreaking ruling by the Colorado Supreme Court. In a momentous verdict, the Colorado Supreme Court declared that former President Donald Trump is disqualified from running for president and holding office. This decision came about because the court concurred with the lower district court's assertion that Trump incited protesters before the infamous January 6 Capitol riot. This act, according to the court, was a clear violation of the 14th Amendment. Now, this ruling wasn't taken lightly by Trump's campaign, which plans to appeal the decision to the United States Supreme Court. The Colorado Supreme Court, understanding the gravity of its ruling and the potential for an appeal, has wisely stayed its decision until January. This move grants a window of opportunity for Trump's campaign to make their case before the highest court in the land. If the United States Supreme Court decides to hear the case, it could have significant implications for the upcoming 2024 presidential election. A favorable ruling for the plaintiff could effectively bar Trump from appearing on the ballot, altering the landscape of the election entirely. This case was initially filed by the nonpartisan watchdog group, Citizens for Responsibility and Ethics in Washington. They argued that Trump's actions during the insurrection should disqualify him from running for president. Critics, however, argue that this ruling infringes upon voters' rights. But election law scholars counter that the Constitution itself has provisions to limit who can run for office. It's worth noting that Colorado has not been a stronghold for Trump in past elections. In 2016, Hillary Clinton won Colorado's electoral votes, and President Joe Biden won the state in 2020. Nonetheless, the ruling could potentially influence other states considering similar challenges to Trump's eligibility. This ruling, while currently stayed until January for an appeal, could set a precedent for similar challenges to Trump's eligibility in other states. The implications of this ruling go beyond the 2024 presidential election. This decision could potentially open the floodgates to a new era of election law, where the 14th Amendment becomes a tool for challenging the eligibility of candidates. If this ruling sets a precedent, we might see similar cases pop up in other states, effectively reshaping the landscape of American politics. The debate about voters' rights versus constitutional provisions limiting who can run for office is a complex one. On one hand, there's the argument that the ruling limits voters' rights. This perspective posits that the people should be the ultimate deciders of who they want to represent them, and courts should not interfere with that choice. But on the other hand, there are the election law scholars who argue that the Constitution, and in this case specifically the 14th Amendment, has provisions to limit who can run for office. This perspective views the Constitution as a safeguard against potential threats to democracy. The 14th Amendment, designed to protect civil rights in the wake of the Civil War, is now at the forefront of 21st century political discourse. Its enforcement could potentially disqualify candidates who are deemed to have incited insurrection or rebellion. This is a clear demonstration of how our foundational documents continue to shape and respond to contemporary societal issues. There's no denying that the Colorado Supreme Court's ruling has stirred the pot. The appeal to the U.S. Supreme Court could have far-reaching implications, not just for the former president, but for the entire nation. It's a moment of reckoning, a moment that tests the resilience of our democratic institutions. While the final chapter of this political saga is yet to be written, it serves as a stark reminder of the power and relevance of the 14th Amendment in American politics. So, can Donald Trump be removed from all state ballots under the 14th Amendment? We've delved into this provocative question, dissecting the lawsuit filed by Citizens for Responsibility and Ethics in Washington, and the consequential ruling of the Colorado Supreme Court. The implications of this case are vast, potentially reshaping the political landscape. While the U.S. Supreme Court's decision remains pending, we can't help but acknowledge the historical significance of this case. While we wait for the U.S. Supreme Court's decision, one thing is certain: this case has already made history.